What is the definition of evidence under the rules? Evidence is defined as the means, sanctioned by the rules, of ascertaining the truth in a judicial proceeding regarding a matter of fact, Section 1. What does Section 2 stipulate about the scope of the rules of evidence? The rules of evidence are uniform across all courts and trials, unless specified otherwise by law or the rules, Section 2. Under what conditions is evidence considered admissible? Evidence is admissible if it is relevant to the issue at hand and not excluded by the Constitution, the law, or these rules, Section 3. What constitutes relevancy in evidence? Evidence is relevant if it has a relation to the fact and issue strong enough to induce belief in its existence or non-existence, Section 4. What are some examples of facts that do not require proof due to mandatory judicial notice? Courts must recognize without evidence the existence and territorial extent of states, forms of government, political history, and laws of nature, among others, Section 1, Rule 129. When may a court take discretionary judicial notice? A court may take discretionary judicial notice of matters generally known or capable of certain verification, Section 2, Rule 129. What is required before a court takes judicial notice during pretrial or trial? The court must hear from the parties regarding the appropriateness of taking judicial notice, Section 3, Rule 129. When are judicial admissions in a court case not required to be proved? Judicial admissions need not be proved and can only be contradicted by showing a palpable mistake or that the admission was not made as claimed, Section 4. Rule 129. What qualifies as object evidence in court? Object evidence includes any item presented to the senses of the court that is relevant to the fact and issue, Section 1, Rule 130A. How are documents used as evidence in legal proceedings? Documents may serve as evidence if they contain data like writings, sounds, or images relevant to the case, Section 2, Rule 130B. Under what circumstances can secondary evidence of a document be used? Secondary evidence is permissible if the original document is lost, destroyed, or otherwise unobtainable without bad faith, Section 3, Rule 130B. What is considered the original of a document? An original document includes any counterpart intended to have the same effect by the person executing it, including data outputs and prints from electronic sources, Section 4, Rule 130B. What allows for the use of duplicates as evidence? Duplicates are admissible unless there is a question about the authenticity of the original or if it is inequitable to use the duplicate, Section 4. Rule 130B. When is it appropriate to use summaries of voluminous evidence? Summaries can be used when the detailed examination of voluminous data would cause significant delays and only a general result is needed, Section 7, Rule 130B. What procedure must be followed if a document is under the control of the opposing party? The opposing party must be given reasonable notice to produce the document. Failure to do so allows the introduction of secondary evidence. Section 6, Rule 130b.